Mr. Brown never planned to kill his wife. He didn't want to kill his wife, but in a moment of overwhelming emotional pain and anger, he lost control and he reacted without thinking.
That you made her disrobe, and that, as Mr. Prater said, you tried to drug her. It's what she told the police officers. You say no. I ain't gonna say he said, you said, because she's dead.
And you have the rifle there. Is that not correct?
Yes, the rifle was there.
Okay, and then you shot her 16 times, correct?
And we are about to watch the parole hearing of a Louisiana man who killed his wife back in 1975. He served over 5 decades in Angola, and at 76 years old is having his first opportunity for parole because of a unique 280 Lifer Act, which will be described for you in this parole hearing. Now, what's interesting about this case, unlike others that we listen to, is that it almost feels like it's being tried in court again. His support, his team insists that it was an act of passion and not premeditation. And the Louisiana Parole Board, they get up there with the facts of the case and try to prove the point that this was premeditation. Because of this, I find this to be particularly fascinating. Now, we have the appeal, so we can go over the facts at the end of the hearing. For now, let's jump in. Oh, and one last thing. There are 24 minutes or so of support conversation. If you want to fast forward to about the 25-minute mark and go straight to the questioning, feel free to do so. But I do think it's important to listen at least to what his attorney says about the halfway point. It's quite interesting, the argument that she tries to make. Now with that, let's jump in.
So, Mr. Brown, you're classified as a first felony offender serving a life sentence. Sentencing was March 8th, 1993 in St. Charles Parish. You received a life sentence for a second-degree murder conviction. Is that information correct, Mr. Brown?
No, ma'am, I was resentenced in 1993. My original sentence was in 95, if I'm not mistaken. I'm sorry, 75.
75. I'm sorry. I do see the resentencing and I do see the original sentencing date, 1975. Thank you for that
Yes, ma'am.
clarification. As I said, your case has been assigned to Mr. Prater, so I'm going to turn it over to him now.
Yes, sir. Mr. Brown, what I want to do is to hear from you first, and then I want to hear from some people supporting you. And then I want to hear from the district attorney in the 25th district. And then we will ask some questions, and then we will take a vote. It's pretty simple. First off, I'd like to find out why do you think that you should be eligible to be paroled at this particular time? Tell us a little bit about yourself, why you're there, and what you've done since you've been there.
Well, I came here to Louisiana State Penitentiary in the year of 1975, March. And since then, I started out in the classification department working at the reception center. Then from there, the classification department at the reception center. Then Mr. Smith, who was the interim secretary of Department of Correction, nominated me to go to wAs for a new program called Lifers Maintenance Program, apprenticeship program. I spent 10 years at wAs learning heating, refrigeration, as well as electrical work. After my 10 years were up there, I came back to Louisiana State Penitentiary where I got into working with the warehouses as a clerk. As a clerk, I needed the use of the computers, so with self-help programs, I took graphic arts, and at the same time, I was tutoring other guys to learn how to get their GED. I also, with the rodeo, there were times when guys needed assistance on a rodeo ground. I would go over there and help them as much as I could. And also, I would make provisions to help the guys in the camp, the ones that weren't able to take care of themselves physically, not to mention, was short on items that they needed, personal hygiene items and so forth and so on. But the majority of the programs that I've taken since I've been here was self-help programs. They will consist of, say, maybe, like I said, helping guys get their GED. I was trying the process of getting the CDL, computer training, which I was taking, and a number of other jobs that presented themselves and was challenging as well.
Okay. Is the warden in the room with you?
Yes, sir. I'm here. How you doing today?
I'm doing good. Would you tell us a little bit about him and how he's been since he's been there?
Yes, sir. Well, he and I got here on the same month and the same year, so I've known him a long, long time. I've seen him progress. He's definitely not the man that committed that murder so many years ago. I do not think that Melvin would go out and commit any more crimes. I think he would be a citizen if he got the chance to go back out and start his life over.
Okay.
He's held the same job for 15 years. He's a transportation clerk for Prison Enterprise. Over at the former office, he's a trustee at Camp F.
Okay. Thank you, Warden. Appreciate that very much. Okay, let's move on to this. Let's move on to the supporters. First, we'll hear from, let's hear from Deborah Brown first. Deborah there?
Yes, sir.
You don't, okay.
I'm sorry.
Okay,
Good
Ms.
morning.
Brown, would you tell us a little bit about your brother there?
Melvin is the oldest, and I am the youngest of the Browns. Melvin was the one that you had to go to when you got off from school because he's more of an educator. He's into a lot of learning. And of course, we as his siblings had to learn too, whether we wanted to or not. But in the years of my brother being here, he's a very patient young man. He has more patience than I do myself. And we keep him informed on the things that is happening in the family. And he's pretty much informed on everything by sending the family members. If it's a death in the family, he'll send a letter. I remember the time when my mother passed, Melvin helped me in getting the funeral arrangements together, even though he was all the way up here. As to the family members, we all seek into helping him. If he's able to come home, I have a place for him to live. That's separate from the family because I know he likes to live his own little comfort zone. And I do have a little area in my home that is welcoming for him. And also he'll be able to help me with my grandbabies to educate them. So I'm very much so wishing and willing, and hopefully my brother gets to come home and spend his years with us.
Okay. Well, thank you for that.
Thank you.
Let's move on to Mr. Hunley with the Louisiana Parole Project.
Thank you, Mr. Prater, and appreciate the opportunity to talk to the board about Melvin. Just a little history. Melvin's parole eligible today because of Act 280 of the 2017 legislature. Back when Melvin was sentenced, life sentences carried parole eligibility after 20 years. So when he received that sentence in 70, back then, a life sentence was parole eligible after 20. That changed after he was incarcerated. And in 2017, the legislature restored that parole eligibility through Act 280. Louisiana Parole Project has done the reentry for the bulk of the dozens of Act 280 lifers who've been granted parole. Melvin's one of the last few remaining Act 280 lifers at Angola. Because he has served more than 50 years in prison, is a Class A trustee, has done quite a bit of programming. And because just our staff is very familiar with Melvin, we have a high degree of confidence that if he's granted parole, that he would be successful. Our organization stands ready to provide Melvin long-term reentry support that includes housing. You know, at 76 years old, we feel confident that we would be able to help Melvin with his reentry into the community. If he's denied parole today, he would have to wait 5 years before reapplying and then would be 81 at that time. Just being frank, his reentry at that point would be much more difficult for our organization and him. In summary, he would have access to our staff social worker and all of the other benefits of being a client, as I said, which includes but is not limited to housing, transportation, and other support services. And I'll finish with asking you to hear from our staff social worker, Supervisor Megan Snedeker, who has completed an assessment on Melvin. Thank you.
Okay, well, that's a good segue. All right, we'll hear from Megan. Megan, would you tell us what you think for the Pro project?
Hi, good morning. I would love to thank you so much for the opportunity to speak and express my support for the release of Mr. Melvin Brown today. As you know, I'm a licensed social worker with Louisiana Parole Project, and I have extensive experience working with individuals who have high needs and who have served long prison sentences. And therefore, we're poised very well to assist him in his transition from incarceration. With the robust support of not only Louisiana Parole Project, but also Veterans Affairs, which I'll speak to in just a minute, I believe that Mr. Brown has the capacity to reintegrate into society and contribute positively to the community. So I did have the pleasure of meeting with Mr. Brown in January of this year. He, as you see today, he presents as a calm, reserved, and introspective individual. Throughout my evaluations, I learned that Mr. Brown is a Vietnam veteran who has endured significant trauma and hardships throughout his life. His experiences in combat seem to have left him with symptoms that are consistent with post-traumatic stress disorder. I'm sure the board is familiar with that. PTSD is a serious mental health condition that can deeply affect somebody's life and can cause emotional and psychological challenges. However, it's important to recognize that individuals with PTSD are not inherently a danger to public safety. They may experience some intense symptoms, but the majority of people with PTSD do lead peaceful lives and are not violent. As you can see, his demeanor today suggests that he's fully capable of maintaining a level of self-control. And he's also shown a willingness to engage in mental health treatment as needed if granted parole today. Based on my professional assessment from our meeting, Mr. Brown would benefit greatly from continued mental health care and services after he's released, particularly services that are specific to veterans. In preparation for his release, I have been in communication with Valence Aber, a licensed clinical social worker who works with the VA's Veterans Outreach Justice Program. The VA and Val Aber are committed to facilitating Mr. Brown's transition into the community by connecting him with critical mental health services. These services look like comprehensive mental health treatment that include individual assessments for PTSD, individual psychotherapy, group therapy, especially when it comes to specific needs such as anger management, stress management, combat support, and individuals who have served in certain combat zones such as Vietnam. Additionally, Mr. Aber has offered to personally assist Mr. Brown in person at the New Orleans VA's office if he is granted release. We are committed to providing transportation to connect him to any of these services that are recommended to him by clinicians at the VA. Mr. Brown's past actions appear to be deeply influenced by trauma that he's experienced during his service, but his willingness to engage in comprehensive mental health services upon his release suggests to me that he's committed to maintaining peace and stability in the community. And the robust support, again, through LPP and through the VA will ensure that he has the resources to address any psychological challenges in a constructive manner, preventing any risk to public safety. Thank you for your time and consideration in reviewing this, and I'll stand by if anybody has any more specific questions.
Okay, well, I appreciate that, but I've got one question. If you could just, you mentioned PTSD, and I was wondering, has he been officially and formally diagnosed with that? Is there a diagnosis for that, or is that just what you're thinking?
No, he does not have an official diagnosis for PTSD. However, I believe Micah Sloan, his attorney, wrote in the brief that Mr. Brown was diagnosed with what they called war neurosis back in the 70s. And so that's why I was very careful to say today that his symptoms are consistent with PTSD, because he has not received a formal diagnosis, which is what we would be hoping to do if we connected him with the VA.
Okay, thank you. All right. Another good segue into Ms. Sloan, his attorney, Micah Sloan. Would you tell us what's on your mind, please, ma'am?
Thank you. Mr. Brown is a veteran. He's a cancer survivor. He's a Class A trustee and an exceptionally intelligent and thoughtful person. He's also among some of the longest serving individuals in the DOC system, having served over 5 decades. He has a unique life story that involves unimaginable tragedy, exposure to violence, and subsequent trauma, but also redemption and growth. He's always taken responsibility for his crime, during which he took the life of a woman that he loved. In fact, he was the one that called deputies to his home on the night of his offense. Mr. Brown never planned to kill his wife. He didn't want to kill his wife, but in a moment of overwhelming emotional pain and anger, he lost control and he reacted without thinking. He has also always felt deep remorse for his actions, so much so that he felt he could not bear to live with the guilt and attempted to take his own life in the moment he realized what he had done. Though he's always felt deep remorse and responsibility, during his incarceration, through programming and personal growth, he's been able to further develop his understanding and the extent of the impact of the harm and the selfish thinking that led him to that moment. After having spent many hours with Mr. Brown and hearing from others who know him, it's clear that Mr. Brown was not himself in that moment in 1974. Because who he really is a humble, a gentle, kind man who has a passion for serving others. His focus in life is to learn, to be productive, and to treat others with respect. Given his reserved nature, there are a select few who really know Mr. Brown, and one of those people is Chaplain Burns. Chaplain Burns wrote a letter of support for Mr. Brown, and in that letter, he wrote, quote, "Melvin is not a typical inmate. He is a man of integrity and goodwill who does not complain or try to manipulate his circumstances. His mission, it seems, is to help others. Having been incarcerated for over 50 years, he has demonstrated a sincere motivation for change and rehabilitation. I deeply admire his positive attitude and relentless pursuit of self-improvement. He truly embodies the principles of rehabilitation that the prison system strives to promote," end quote. This is what I and the Parole Project see in Mr. Brown as well. Mr. Brown has served his sentence humbly. He has received only 36 disciplinary infractions in 51 years. He works hard as a clerk in the Transportation Department of Prison Enterprises, where he's held a position for actually over 17 years. Even on challenging work days, he's grateful for the opportunity to have been helpful, productive, to have learned something new. He has this almost whimsical perspective that every new challenge and new encounter is an opportunity to learn. Mr. Brown is also a very skilled sewer, and he is constantly seeking new skills to hone. Every time I greet Mr. Brown and I ask him how he's doing, he responds, "I can't complain." And he truly doesn't complain. It's his deep remorse and his understanding of the pain that he caused that humbles him. He understands very clearly why he's here and what he must do to show that he's not the man that he was on that evening in 1974. As mentioned, Mr. Brown is a Vietnam veteran. For about a year, he endured and witnessed unfathomable violence and loss as he fought in combat for our country. I don't think you need to be a mental health expert to realize that combat in a war zone can have a significant impact on someone mentally and emotionally. When the United States Army drafted Mr. Brown, it prepared him to go to war, but it did not prepare him to come home, which to Mr. Brown was the hardest part. Prior to his trial, Mr. Brown was diagnosed with untreated war neuroses, a condition which today would very likely be PTSD, as Ms. Snittiger mentioned. His condition has remained untreated, and Mr. Brown has silently continued to suffer from related symptoms. He is cautious of his safety almost constantly, a feeling he's not been able to shake. Therefore, he often chooses independent activities like reading, sewing, or crocheting to avoid even the possibility that conflict could arise. While incarcerated, it was only moments when Mr. Brown felt his safety was legitimately threatened that he responded physically, a response he deemed necessary to protect himself from physical harm. I was pleased to discover during my representation of Mr. Brown that the Department of Veterans Affairs, the VA, had developed this program that Ms. Snittiger mentioned, the Veterans Justice Outreach Program. It's a program designed specifically for veterans like Mr. Brown who have come in contact with the justice system. I learned through my research that actually a disproportionate number of veterans do become incarcerated, and it's often due to reactionary, sometimes hostile behaviors that can be traced to common conditions in veterans, such as PTSD, or simply the type of training that they received in order to survive in a war zone. For this reason, the VA recognizes that although some veterans may have caused harm in their communities, they're no less worthy of VA services, and in fact, especially need those specialized services that they offer to treat war-related mental health concerns. As Ms. Snittiger mentioned, our team has made contact with a social worker at the Justice Outreach Program at the VA who's willing to personally accompany Mr. Brown as he navigates the eligibility and enrollment processes at the VA if he's released. These are services that I believe Mr. Brown needs and earned by serving our country, but does not have access to unless he's granted parole. If Mr. Brown is denied parole today, when he's eligible to reapply, as Mr. Hunley mentioned, he will be 81 years old and he will have served 56 years in prison. Although time, of course, will have passed, the majority of the circumstances before the board today will remain the same. The facts of his offense, the pain felt by Mrs. Brown's family, Mr. Brown's heartfelt remorse, his record, the courses he's taken, the impact that trauma has had on him, that will all remain the same. What will be different, however, in 5 years is that Mr. Brown will have more needs, as anyone in their 80s will. He may not have the same ability to work as he does now. He would likely have additional medical needs. He may have mobility issues. His siblings and family who are also getting older may not be able to provide the same kind of support, all of which will make his transition more difficult and more difficult for the Parole Project, who, God willing, will still be here to support him then. I say that to say that now is the time to grant Mr. Brown parole, because it's now, with the dedicated support of the Parole Project and Mr. Brown's family, coupled with targeted VA services, that we can confidently say that Mr. Brown can and will be a safe, contributing member of our community and live a productive and peaceful life during the years he has left. When Mr. Brown was sentenced, all parties involved, the DA, the victim's family, the judge, the jury, all understood that Mr. Brown would one day have an opportunity of parole. And in fact, he served 25 additional years than what was additionally anticipated before he came before a parole board. 51 years is a long time. And for Mr. Brown, it's been valuable time to reflect, to learn, and to become a better person. He valiantly and bravely served our country. He has humbly served his time for his crime, and he's well prepared to re-enter the community where he can finally receive the VA services that he's due. He's not a safety risk. He's capable of working, and he has a wide range of supporters and providers who will be dedicated to him, including the Division of Probation and Parole, who will ensure that he's successful upon release. There's no doubt that Mr. Brown committed a terrible crime. He will forever live with the remorse, pain, and shame of having done so, whether he's incarcerated or not. But he is rehabilitated, and he's paid his debts to society with 51 years of incarceration. Having borne witness personally to Mr. Brown's unique intelligence, broad range of skills, and kind-hearted nature, I feel confident that our community will be better with Mr. Brown in it. It's for these reasons that I ask this board to grant Mr. Brown the opportunity to serve the remainder of his sentence and what years he has left on parole. I'd like to just quickly add also that Mr. Brown has shown an interest in retaking the Cage Your Age course. And so if the board deems that an appropriate condition of his release, we'd agree that such would be fair and appropriate. And further, Mr. Brown has no intentions of returning to St. Charles Parish, so there'd be no issue with this board requiring that he not return as a condition as well. Thank you very much for your time and consideration.
Hey, thank you, appreciate that. Let's move on to Mr. Juan Bird with the 29th Judicial District, Assistant District Attorney. Mr. Byrd, are you with us?
I am, sir.
All right, would you tell us what you're thinking?
Good morning. Well, when we started this morning, my office, I have to say my office right now is waiting on a jury to come back on a second-degree murder. And so here I am today to discuss the parole for someone who committed murder in St. Charles Parish. And when I started, my position was that that parole should be denied. However, I've listened to the statements by all parties, and I will change my position. I cannot change my position to support, but I will change my position to taking no position on this matter, and I'll let the parole board, in their wisdom, make the decision on what should take place with Mr. Brown.
Okay. All right, thank you for your comments, sir. We appreciate that. Mr. Brown, let me ask you a few questions now. And then the board members will have a chance to ask you. Let's go back to the occurrence. Did you go and buy keep in mind, I know most of these answers because we've been studying the cases. The rifle that you used to shoot your wife 16 times with, how long had you had that gun?
Since I moved to St. Charles Parish, sir, we were shooting rats and stuff like that when we around the house and stuff because it was a rural area.
Okay, so you hadn't just recently bought that gun.
Oh, no, sir.
Okay. All right. Tell me about the afternoon or the evening before the murder when the police were called to your house.
Well, we was in St. Jefferson Parish, and I asked my wife to come in the car so I could talk to her. My mother told her something I couldn't hear, but what I done was, out of rage, I hit her car. So that's when my wife said, okay, I'll come. So she got in the car and we drove to St. Charles Parish. When we got there, we started talking and one word led to another and we got into a heated argument. From there, I just don't know what happened. The rifle was in the hallway. I don't even know how it got in my hand, but I just snapped.
Okay. Let's go back before that incident. When the police were called a few hours earlier, were they not called to your house?
Yes, sir. They were called to my house.
Okay, and that's when you got your wife from work and you took her home. And tell me about that.
Well, the problem arose when my mother-in-law was me and her was constantly in dispute. And my wife said that she would handle the situation. And as time went on, situation wasn't resolved. So it got worse and worse. So that's why we moved from Jefferson Parish to St. Charles Parish. But as time went on, the problem that we left caught up with us. And each time that we had a discussion in reference to her mother, she said that she would handle the situation. So not having another option to move, we constantly got into heated arguments. And one word led to another and another and another. And I just snapped.
Okay, before you snapped, what I'm getting at is your wife, the victim, deceased, she told the police, according to the police reports, that you picked her up at work, took her home, that you forced her to get undressed, and that you tried to make her take sleeping pills. And this was a few hours before the killing, and that the police actually took you to the substation. Is that correct?
Yes, sir, that's correct.
Okay, and so then a few hours later is when, okay, am I right about the first incident? I'm just trying to get it straight because you're kind of glossing that over. I want to make sure I'm trying to get at the premeditation deal because you thought about this. It wasn't like you just snapped. Hours earlier, you actually were there fighting with your wife, and the police told you to stay away. Is that not true?
That wasn't the same day, sir.
The police report says it was the same day,
Might I clarify?
a few hours earlier. Yeah. Yes, ma'am.
From reviewing the trial transcript, what I believe is the same day as the offense, the police were called to Mr. Brown's home. And the police did pick up his wife and take her with them. But Mr. Brown was not arrested in that moment.
Right. I didn't say he was arrested. I thought they took him to the substation and he agreed not to go back over to his wife.
It's not, at least from the trial transcript, it's not clear what the conversation was, but it does not appear from the transcript that he was taken into the substation.
Okay.
I hope that.
But I'm right about the incident occurring that same day. Okay, we'll fast forward then to where your mother-in-law and your child and your wife are in a car, correct? And
Yes,
that
sir,
you
that's
pull
right.
up, you pull up near them, correct?
Correct.
What happened then?
I didn't only pull up next to them, I hit their car.
Okay,
And when I hit their car, that's when my wife said she would come with me. She did get in the car and we drove to St. Charles Parish. As we were driving, I was asking her about why she didn't talk to her mother about trying to get away from us. And she said that she would handle the situation. We got in St. Charles Parish at the house. We were, I should say, drinking a cold drink or something like that. But as we were talking, discussing the information, passing the information by, we got into an argument and one word led to another.
okay. After you seem to be forgetting something. After you hit the car,
Yes,
your mother-in-law get out of the car?
yes, she did.
Did you
She got
chase
out.
her down?
Yes, I did.
Did you choke and hit her?
Yes, I did, sir.
Okay, that was the mother-in-law. That's the mom. That wasn't even the wife.
That was the
Okay,
mother-in-law.
and then you got your wife into your car again. Or did you run over your mother-in-law and break her leg?
No, sir. I hit the car. I didn't hit
What
my
now?
mother-in-law. No, she was in the car as well as my wife.
Okay, how'd her leg get broken?
I have no idea, sir, but she was in the car when I hit the car. My son was in the back. She was behind the driver's seat, and my wife was on the passenger side.
And then you have your wife in your car for the second time within hours. This wasn't when you picked her up from the work. This was when you hit her car and put her in your car.
I think about 2 different days. That doesn't work out. It was 2 different events.
Yes, it is, but just a few hours apart. That's what I'm getting at. Okay, and so you take her to the house, and that's when you actually get in a fight with her at the house while your mother-in-law has gone to the hospital from the wreck and the choking and all of that. She's gone to the hospital. You got your wife, you go to the house, and you have the rifle there. Is that not correct?
Yes, the rifle was there.
Okay, and then you shot her 16 times, correct?
I don't remember how many, but I'm sure you're right.
Okay, and then you shot yourself in the side, correct?
Yes.
Okay, and then, anyway, then you get arrested and you denied it after you had admitted it, then you denied it and went to jury trial, is that correct?
Did the transcript say that? I don't recall denying it, sir.
Okay. Well, I just assumed that you had denied it because you went to the jury trial. But you might not have denied it. I don't know. I read in one of the reports that you did. But regardless of that, then you go to a jury trial, and then you're found guilty, and then you're sentenced, correct?
Yes, yes, right. That's
Then you did a lot of good things. Let's move to the good things you did. Once you get in jail, you did a lot of growing over there, but you did have a lot of disciplinary conduct write-ups. But when I say a lot, we're talking about a lot of years, so less than one a year. So that's not really that bad. Let's move forward to 2019 and 2020. Did you get in trouble? That hadn't been that long ago. Did you get in trouble then?
in 2019?
Yes, sir.
Yes, sir, I did. At Camp F, I was experiencing prostate problems. I was urinating 25, 30 times within a 24-hour period. There was a young man who was transferred back there to Camp F who didn't want to be back there. So he was told that if he didn't want to be back there, all he had to do is take his lockers and slide him to the sally port and they'll move him. But he didn't want to appear as being a checkout. So he looked for an easy target. Apparently he picked me as an easy target because he accused me of watching him while he was taking showers and so forth and so on. So as long as he was talking, didn't concern me, didn't bother me whatsoever. I just watched him. But this one particular night, Sunday, when I was going to the restroom, he happened to be coming out of the shower. As I was using the latrine, as I passed behind him, he brought to my attention that I didn't say excuse. So I told him I didn't have to say excuse because I didn't touch him. And he said, well, I'm gonna put that knife on you yet. And when he said that, based upon what I know from being incarcerated, that I was protecting myself to make sure that the knife wasn't put on me. So evidently before it was all over, I hit him in the head to separate me from him. I didn't want to kill him, I just want to separate us. At that time, a few minutes later, security came, escorted him out there at the dorm. A few minutes later, they came back and got me and escorted me out of the dorm.
Okay, what'd you hit him with?
A piece of pipe.
Where did you get the pipe?
Was hobby shop.
So you had gotten the pipe in anticipation of hitting him.
No, sir.
So
The pipe.
they just let you have pipe in jail?
Oh, no, sir. There was a construction work that's being done in the dormitory, one of the heaters and stuff like that, and some of the equipment and material was still in a dorm.
So it wasn't a hobby shop.
No, I say it comes from the hobby shop.
And that doesn't make sense. Maybe one of my corrections.
Did you take the pipe from a hobby shop and bring it to your dorm, or was the pipe already in your dorm?
The pipe was already in the dorm.
Well, how did it come from the hobby shop?
No, this was a piece of pipe that was used in the hobby shop for bending metal. They use it in the dormitory to bend the metal, I think 90 degrees or whatever degrees it is, to make it go through the wall. Whoever the maintenance man was, they forgot it and left it in the dormitory.
Okay. And you just happened to have it with you when you was coming out of the bathroom?
Oh, no, sir. It was on the counter.
Okay. That's something there's. All right. Okay, we got a letter. Tell me about shooting yourself in the side. I'm curious about that. How come you didn't shoot yourself in the head?
If I'm not mistaken, sir, that's not in the side. I hit, the doctor told me if it was a 1 or 2, I think he said something like millimeters, something like that, it would have hit my heart. And I still have the bullet in my chest, and 2 of them went straight through me.
Okay. All right, that's all the questions that I have.
What kind of rifle did you use?
It was a 22, sir.
I was wondering how you had so many shots. Okay, so you're saying you shot yourself 3 times then? 2 passed through you and 1 ended up in your chest?
That's what the doctor said, sir.
Okay.
All right.
Use a statement.
Yes, I got some questions. Okay, so the first incident that Mr. Prater tried very hard to understand what I'm fixing to try and understand right now. The first incident happened, she was at work, correct? That day, the same day, January the 4th, you show up at work. Am I correct?
Yes, sir. Yes, ma'am.
Okay, and you ask her, and you ask her, she must have worked in St. Charles Parish, is that correct? Did she work in St. Charles Parish?
No, ma'am. She worked in Jefferson Parish.
She worked in Jefferson Parish, okay? She liked Jefferson Parish, it seems like. Felt safe in Jefferson Parish, is that how I read it? Okay, so you come in your truck to her place of employment, and you ask her to come out to your truck, is that correct? So you can talk.
Yes, ma'am. That sounds correct.
Okay, how long had y'all been separated at that point? You were not living together in the same house. She was living in Jefferson Parish, you were living in St. Charles Parish. How long had that been going on?
No, she wasn't living in Jefferson Parish.
But was she living with you?
No, ma'am.
No, okay, so she's got here in the police report that she told the police officers, possibly when you weren't around, that y'all had been separated by that time for 3 months, okay? So you just said y'all were not living together. I don't really care if it was 1 week or 3 months. She said 3 months. Okay, so y'all were living separate and apart. She wanted it that way. She said that when you got her to the house y'all used to share together in St. Charles Parish, correct? That was y'all's previous home?
Yes, ma'am.
All right. And she was not sharing that home with you at that time?
No, ma'am.
No, okay. That you made her disrobe and that, as Mr. Prater said, you tried to drug her. It's what she told the police officers. You say no. I ain't gonna say he said, she said, because she's dead. All right. So you can tell how I'm feeling about all this right now. And she also said you had a rifle because she had a chance to call law enforcement to come there from St. Charles. They could not find the rifle. So they take both of y'all to the St. Charles Sheriff's Office. Is that correct? Y'all both end up over there.
Yes,
St.
ma'am.
Charles. Okay. At that time, she tells her story, basically what I said, and they tell you that what you did was wrong. But basically, I guess you would say she wanted to get in that truck and go somewhere with you to y'all's home. And if she was here, she might say, no, she didn't want to. She just wanted to talk to try and keep things at a decent level between y'all. That's not uncommon during a separation. But anyway, they said what you did was wrong and you apologized to her. Is that correct?
That's correct.
That's correct. So that was around 4 p.m., the time frame, 4 to 5 p.m. that afternoon. I don't even care. It was because they had to put it in their report. So here's the next thing she says. Common. She really doesn't want to get you in trouble, so she's not going to press charges, but she wants you to leave her alone. So in addition to that, she says to the St. Charles Sheriff's Office I want to be brought back to Jefferson Parish where I feel safe. That's where she was staying. So the St. Charles Sheriff's Office brings her back to the St. Charles Jefferson Parish line. And they hand her over to the Kenner Police Department. Am I correct about that? Or you maybe don't know, but you know that the sheriff's office left with her, right? And she ended up in another location. So I'm still on the right track, okay? So, okay. So later on, so she's gone to what she thinks is her safe place. She said, leave me alone. Again, because she's separated from you. She said, leave me alone. So that's pretty doggone clear. And then she and her mother was driving with your child. Is that correct?
That's correct.
How in the devil did you get behind them? Were you watching them? That you could plow into the vehicle? What were you during all of that if you were staying away?
Where was I?
Yeah, how did you know they were on the road and where they were at if you were staying away?
Well, she wasn't on the road. She was in front of her auntie's house.
So you went over to her auntie's house in your vehicle?
We all family members know where everybody else stays.
I know, but you were asked to stay away. And you didn't do it.
No, I didn't.
No. So that's what some people would think is premeditated. Because you made a deliberate effort to go back to where you were already told the same day, stay away, leave the lady alone. She doesn't want you around, but you didn't do that. So then you said, which I didn't read, that then you hit the vehicle that had her, your mother-in-law, and your child. And how old was your child?
About 4 years old.
4 years old. So daddy hits the car that the 4-year-old was in with her mother and her grandmother, correct?
Yes, ma'am.
So at that point then, you said that the mother-in-law was y'all's problems. And that your wife said she was going to take care of things, correct?
Yes, ma'am.
And she wasn't doing it. So now you've decided what? That you're going to take matters into your own hands. Because you're angry. It sounds like you ran around the car. Correct?
Yes, ma'am.
Okay. So then at that point, mother-in-law gets out of the vehicle. Am I correct on that? When the mother-in-law gets out, I guess she was going to confront you. Maybe or not.
Say that again?
Okay, so who gets out of the vehicle when you ram it?
The mother-in-law.
Mother-in-law. And so that's how you get the opportunity to strangle her, right?
Yes, ma'am.
And you do or don't remember running over her with the car, breaking both of her legs.
I didn't run over with the car.
Oh, how did she get her legs broken?
I have no idea, but I didn't run over with the car. When she got out of the car, she was on the passenger side. Correction, the driver's side.
Okay. And she was out of the car though. And that's how you strangle.
So
So,
when I hit
and the
the
child
car,
was already in safe. The child was somewhere safe already. Undoubtedly, there was a witness there that I guess you said she was at the auntie's house, so maybe a family member got the child to safety, correct?
the child was still in the car in a safe place. When I hit the car, I hit the front end of the car.
In front end, okay.
Yes, ma'am.
And the child was still in the car.
You're still in the car.
So child witnessed you strangling her grandmother in the
Yes,
car?
ma'am.
Okay.
No, she was on the ground then. She got out of the car.
Right. There we go. Mother-in-law got out of the car. You're angry with mother-in-law, so you start strangling the mother-in-law. She was the source of your troubles. Is that correct?
That's correct.
Okay. And then you end up with the wife in your vehicle, right?
Yes, ma'am.
And then from there, you take her back to the house y'all shared together, correct?
Correct.
St. Charles Parish, where she didn't want to be. And there is the rifle that nobody could find earlier in the day. Isn't that amazing? How did that happen? I mean, sheriff's office had just been there the same day, couldn't find the rifle, and now it's there. Tell me how
When
you
they
got,
came in,
was it?
when the sheriff's office came there the first time, they didn't go through my house, what you would say, search the house.
They
didn't
didn't?
search. No, ma'am, they didn't search the house. They didn't come no further than the living room.
Oh, the
I mean,
gun off. So in
Ma'am?
other words, then now we got a rifle, and now you kill her. You shoot her 16 times. And it wasn't premeditated. And that's all my questions.
Okay. All right. I just have one question, Mr. Brown. Since you've been in Angola, have you had a mental health evaluation?
No, ma'am, not that I'm
Yeah.
aware of.
You've never had a mental health evaluation?
Not that I'm aware of, no, ma'am.
I don't see any other questions. I think that we are prepared to vote, Mr. Prater.
Yes, ma'am. My vote is that this, that if parole request, even though he's been model person, since he's been in jail, because of victim opposition, law enforcement opposition, because of the seriousness of the crime, and what I think that continue to have anger and fighting problems while in custody. I don't think I would feel good voting to allow him to get on parole tonight.
Mr. Barrow,
I concur, Mr. Prater, for the same reason.
Mr. Prater.
My vote would be to grant due to the age of the offender. I do not think he's a threat to public safety. And good comment from the warden.
Mrs. Stapleton.
I concur with Mr. Prater, and I would add, your good deeds are wonderful, and I'm glad you've had the opportunity to do all of this. But it doesn't negate the heinous, deliberate nature of the crime that was committed.
Mr. Brown, my vote would be like Mr. Freeman's. My vote would be to grant. We heard from the district attorney's office. They take no position. There is very strong opposition that's never going to change. You were denied back in 2000, I believe, 18, and were encouraged at that time to reapply for another hearing. And you've done so. You've done good work since. You've had positive remarks from the warden. So my vote would be to grant to the parole project plan long-term. However, today it requires a unanimous decision. You didn't get that today. So the outcome of today's proceeding is that your parole has been denied. So good luck.
Thank you.
Well, that concludes our business. We're adjourned. It's 10:29.
Okay, so let's unpack this. I gotta tell you, I thought the parole board did a wonderful job. The side by side, you have Miss Stapleton, the victim's advocate, the one who replaced Mr. O'Shea, and the sheriff working side by side. That is a team. That is really something else to see them in action, and they take their job seriously. And it almost feels like his support team is not. I mean, they're all there, and yet they are taking the approach. This was a crime of passion. This was not, premeditated. This was, and it's like, well, if you're going to take that, first, I don't know. To me, it's like, how can you try to take that approach? It clearly wasn't. They list out all of the facts, and they just come up here and try to say, no, don't look at the facts. Don't listen to any of the facts of the case. Let's just listen to us because we said so. And it's bizarre to me. It's bizarre to me that they will go through the facts of the case. Then you have the DA that shows up. We've never seen this DA. I'm happy that you showed up, Mr. DA. We need to see you show up more often. But that was lackluster. I mean, have some pride. I get that you're in the middle of a second-degree homicide trial. You're waiting for the verdict. I don't know why that's even relevant, though. It's like, yeah, that's your job. You probably do that, right? But this man's life is on the line. Did you do any homework? Do you know what? Show up and make a point. Make a point. I'll leave it after hearing what they say. I'll leave it up to the, no, go in there with the statement. I don't know. That pissed me off. And It does. It blows. It really, to me, it blows my mind that you can go all these years later and kind of just and try. And it was a horrible hearing. He had a horrible hearing. And when they painted as to how he's basically like what Miss Stapleton kept trying to get at was like he was stalking her. He was stalking them. He was told to go away and he chased her down. He attacked his mother-in-law. I mean, frankly, I mean, if all of us attacked our mother-in-law whenever we felt like strangling our mother-in-law, we might all be in prison. But no, we have to hold ourselves back. We have to control ourselves, right? But he does it in front of his kid. And like he denies everything. Oh, the broken legs. And it's interesting. I in our report in the appeal that we have, it doesn't talk about broken legs. It talks about him biting her, though. I don't know. It was just, it's like it could have been easy to almost root for him. Not really, when you find out he shot her 16 times and bit her mother in front of her child and stalked him and all those things. And it's like, well, you send our children, basically our kids, our boys out to Vietnam and fight in the jungle, and what do you expect? They're going to come back. But we've covered many Vietnam War veteran cases that are a lot easier to empathize or sympathize someone's plight. You know, there was one man that really stuck out to me. He had fought in Vietnam, and they spoke about his war record, and it was a long record of many medals and all that stuff. You know, there was no doubt that he had been serving and fighting in combat, and the person he killed, it clearly was a sign of passion. His boss called him, I think, the N-word, and he went to his car, pulled out a gun, and shot him. And that's just so much easier to understand, and why you would say, yeah, you know, versus this stalking of his wife and brutalizing and then shooting her 16 times. That's just me. I'm just a man. You can have your own opinions on the matter. So Lady Holly has the document for us, and we have the appeal, and then we have our fun fact of the day. Holly's dropping in fun facts. So the fun fact today is Louisiana has a law that says mourners have a 3 sandwich limit. And it's interesting. There are a lot of crazy laws out there for every state. Obviously, it's not enforced. I wonder who made that. Is it like a way to try to make it more affordable for people who are paying for the, I don't know, sandwich? Okay. That's another thing we could dive into, but let's look at the appeal. All right. The defendant was separated from his wife on the day of her death. Earlier in the afternoon, he had persuaded her to return to the residence. The police were called afterwards. Mrs. Brown then informed them that she desired to return to her mother's house, where she had been residing since the separation. Later that day, the defendant's wife and her mother left the latter's home to go shopping. When they stopped at a friend's house, the defendant, who had apparently followed them in his vehicle, ran into their mother, then alighted and grabbed and bit her. So when they say ran into her, maybe that's what they're talking about when they broke, you know, actually ran into her, not into her car, and bit her. This part they left out in the hearing, and then took his wife into his own vehicle and turned to his own home with her. The police went to the defendant's home. They found the wife shot dead, with the husband beside her still conscious. The defendant told the officers that he had also shot himself in an attempted unaliving. The principal assignment of error, blah, blah, blah. The beating, okay. In opening statements, the prosecutor and in objected to state evidence to the beating of the mother immediately preceding the kidnapping of the wife and the attempted unaliving of the husband. The defendant contends that these involve prohibited references to unrelated other crimes. So this is part of his appeal, is saying you couldn't tell the jury that he beat his mother-in-law. However, the beating, kidnapping, and the unaliving all occurred shortly before, within an hour. And this is what he kept denying. He kept denying. He kept saying it was 2 separate, like the whole thing. I don't know, the whole, or maybe they were talking about other separate events. I don't know. Or after the murder of his wife, they were independently admissible as part of a, of course they would be admissible. Okay. And I think that's kind of, let's see what else they say. The defendant took his wife from her mother's automobile and brought her back home. When the police arrived shortly afterwards, they found the door open and walked in. They saw the defendant's wife dead on the floor and the defendant himself lying beside her, both shot and bleeding. The assignment is based on the contention that the police officers did not first give his Miranda warnings before asking the husband what had happened. That's stupid. Well, I don't know. I guess it could be an argument, but come on. Therefore, it is argued the statement had made at the time that he had shot his wife and tried to kill himself was inadmissible. So they're saying it couldn't be admissible that he admitted to it because they should have read his Miranda rights. However, Miranda warnings are not essential prerequisites or non-custodial general on-the-scene interrogations to determine facts relating to whether crimes be committed or by whom, at least absent when showing the questioning pacifist. Okay. The other assignment of errors are what? I don't see anything major here to talk about. Let's see if you had such, no, he really had nothing to, he had no leg to stand on. This was crazy. But the funny part is that look at this one. The defendant's argument to the jury. So this is what the defendant's argument was. He really had nothing. He had nothing. He had a confession. They had all the evidence. They had everything there, and he still is taking it to trial. And he says that it was essentially that there was still reasonable doubt. There's the jury. Listen, there is still a possibility that a third person might have shot both the defendant and his wife. It was the third invisible person that showed up there and did it, and not that the defendant might have shot his wife, or wife. Not that the defendant might have shot his wife in self-defense. So, okay. So maybe at some point they were saying it was self-defense, but then they said that, no. It's possible there was a third man that did it. I mean, he totally, he even told the sheriff, he shows up all these years later saying, I never said I didn't do it. It's like, what are you saying? Just like own it and try to, you got to own it. And you got to like, if he had taken, I think the side that he could have taken a different approach, but the whole idea that it was a crime of passion, I don't know, that just seems stupid. It is interesting though. It does, if you believe him and what his doctor said about his unaliving event being a genuine one in terms of the bullet still being there and only missing his heart by centimeters, that is an interesting thing, but it also is something that we see quite often in unaliving events where the bullet can come really close, but they never had an intent to end their own lives. They just had an attempt to hide it, and maybe it was luck that they survived, but you didn't get the, if you wanted to take himself out, you can put it in the head. So anyways, what do you think? And with that, I'll let you go.
Mr. Brown never planned to kill his wife. He didn't want to kill his wife, but in a moment of overwhelming emotional pain and anger, he lost control and he reacted without thinking.
That you made her disrobe, and that, as Mr. Prater said, you tried to drug her. It's what she told the police officers. You say no. I ain't going to say he said, you said, because she's dead.
And you have the rifle there. Is that not correct?
Yes, the rifle was there.
Okay, and then you shot her 16 times, correct?